It's 12 o'clock on Tuesday, January the 30th. The House Criminal Justice Subcommittee is now in session. Madam Clerk, please take the roll.
Representatives Davis, Fritz, Gillespie, Hardaway, Howell, Halsey, Johnson, Lamberth, Moody, Russell, Towns. Chairman Doggett.
Present.
Chairman Doggett, you have a quorum.
Thank you, ma'am. Members, do we have any personal orders before we begin today? Seeing none, we'll go to our Sergeant of Arms, Mr. Tyler Muniz. Welcome back, sir, for our weekly words of wisdom.
Good morning, everyone, and good day. Today's words of wisdom are brought to y'all from a famous Tennessean, Justin Timberlake. Gossip is called gossip because it's not always the truth. Have a great day.
Thank you for that. All right, members, we're going to go through the calendar. We've got one item here, item number 10, House Bill 1718, that will be rolled 1 week. That bill was by Representative Gillespie. Item number 1, House Bill 1640 by Leader Lamberth. It will be presented by Representative, be presented by Leader Lamberth. You're recognized. There's an amendment code 12019. You wish to be recognized on the amendment?
Yes, sir, Mr. Chairman. If I may, this bill...
We'll need a motion and a second on the amendment, please. All right, you're recognized on the amendment.
Mr. Chairman, I'm going to speak just basically to the bill, and then Representative Williams, Chairman Williams, will be taking over to present the amendment, if that's okay with you, Mr.
If you don't mind, we'll go ahead and attach this amendment onto House Bill 1640, and then we'll talk about the bill. Is that good?
Yes, sir. Before we attach that, would you please recognize Chairman Williams? I think he has a presentation on the specific amendment.
Okay.
Thank you, Mr. Chairman.
Representative Williams.
Thank you. Thank you, Chairman and members, for your indulgence. The drafting code of that amendment that was before you is 012019er. For the purposes of that bill, what changes about this bill will now, with the adoption of this amendment, will be called Jillian's Law. With us today, we have the parents of Jillian Ludwig, Matt and Jessica Ludwig, and her college roommate, Olivia Mihalovich. I think I said it correctly. And so they're here to communicate on this bill. I just wanted to give you a little bit of background information. As many of you may know, the Ludwigs lost their daughter last year to a stray bullet from a gun that happened because of the challenges that this law seeks to fix. Jillian was a rising star. She was in the same dorm room as my freshman daughter at Belmont. She was accomplished and driven and had worked so very hard to get where she was at Belmont, just riding the crest of what would surely be a successful and promising collegiate experience and subsequent career in the music industry. At age 17, she started her own project called Playing It Forward, where she would perform to raise funds to donate back to those within her musical community that she both loved and could not afford the services of the music school that she attended. Jillian also herself became a teacher of music at Lake House Music Academy, where she had studied. And and upon high school graduation, she went on to study music business at Belmont in Nashville. She had dreams of having a career in the music industry as a recording artist and producer. We have the idea here today, with the permission of the Ludwigs, was to continue Jillian's legacy by naming this bill after her, in hopes that no parent or no Tennessean would ever have to face the same tragedy that they've experienced. Thank you for your indulgence.
Thank you for that. Members, do we have any questions on the amendment? Seeing none, let's vote to attach this amendment code 12019 on the House Bill 1640. All those in favor say aye.
Aye.
Those opposed? Ayes prevail. We adopt. We're on the bill as amended. Leader Lambert.
Thank you, Mr. Chairman. And as amended in just a moment, if we could go out of session and hear from the Ludwig family and Jillian's friend, but I'll give you just a brief explanation of what the bill does. So I practiced law for almost 20 years, been in and out of most of the courts in the Middle Tennessee area. And over, it is brought up that there are folks that come into the court system that have severe mental health issues and developmental disabilities. And yet what happens in many of those cases, and unfortunately what happened in this horrific incident, is that those individuals have their cases dismissed, they are released without the services they need, and they go on to commit new crimes, and many times very dangerous crimes. They are a danger to themselves and others. This bill would say if you are charged with a crime and there's two doctors and you have counsel, you have due process, you have everything in the system that's in your favor, and yet still the judge finds that you're not competent to assist in your defense. So you are so far degraded in your mental health or developmental disabilities that you cannot even discuss your case with your lawyer. That instead of that case just being dismissed at that point, that person would be committed to a mental health or other type of facility for their needs. And then the court would keep up with that individual and monitor their progress until which time they ever regain competency or potentially for the rest of their life, whichever is appropriate. And so that's what this bill does. There are several bills that I've filed over the years that would save lives. But I am quite confident that if this bill had been the law of the land, that Jillian Ludwig would still be with us, that this family would not be in this committee today, that her roommate would still be doing whatever they do at Belmont on a regular school day. And after we hear from them, I'll take any questions on the bill, and I would ask this committee, hopefully unanimously, to support this legislation. But I obviously respect anyone who might vote no that has policy considerations here, and would remind the family that each member has their own district that they represent. But I would ask for a strong vote of support when we're done with this, because I do think it will make a massive difference in making our state safer. Mr. Chairman, with that, if we can go out of session and hear from the Ludwig family, I would genuinely appreciate it. And I know Chairman Williams would as well. I will say I deeply appreciate Chairman Williams working with this. We have been equally yoked on this bill, and he has worked passionately on this, and I deeply appreciate that of him.
Okay. Thank you. Members without objection, we will go out of session. Mr. and Ms. Ludwig, thank you for being with us today. We will give you each 3 minutes for comments, at which point after that time is up, members may ask you questions or share statements with you. On the table in front of you, the microphone, it looks like a picture of a person speaking. You can push that button, that light will turn red. If you will, introduce yourself for the record, and then you'll have 3 minutes each for comments.
Matt Ludwig. Good afternoon. Thank you for the opportunity to speak to you today. Allow me to tell you a little bit about our daughter. Jillian Ray Ludwig was, quite simply, exceptional. She was an amazing, vibrant, and talented young woman. She was a loving daughter to her mother and me, a role model older sister to her younger brothers Shane and Trevor, a beloved granddaughter, niece, cousin, and friend to many. She was a scholar, an accomplished musician, a service-minded young citizen who used her talents and love of music to give back to those in need, those who might not have the means, opportunities, or access to music education like she did, because she knew there are so many out there who share her dreams and deserve a chance to reach them. We were so mesmerized by the adult Jillian was becoming, confident, driven, beautiful, independent. Her mother and I were so proud. We had considered colleges in Philadelphia and other cities, but we felt that Nashville would be a place she would be safe. Instead, the laws and judicial system allowed a violent criminal to be on the streets, and he took her life just as she was hitting her stride. Her future was stolen, and our family will now live with insufferable grief for the rest of our lives. Jill's journal entry from Monday, November 6th, the day before she was shot, outlined some of the goals she had set for herself in the coming month. She had made a, quote, commitment to achievement, as if she was not already an achiever. She expressed love for her new Belmont friends, her old friends back at home who she was looking forward to seeing at Thanksgiving, and for her dear boyfriend, Thomas. She was enthused, determined, and optimistic. She had so much ahead of her. She promised herself she would continue her efforts to live a healthy lifestyle, including maintaining her running routine. The next day, a sunny Tennessee autumn afternoon, she went for a run in an NHL park a few blocks from her dorm and we all know the outcome. Jillian should be alive today. She should be sitting in a classroom right down the road at Belmont, expanding her knowledge, experience, and talents to continue the powerful impact she had in her 18 years into what should have been and would have been an even more impactful presence in our world for decades to come. We are confident that in short order, Nashville and beyond would have known the name Jillian Ludwig, but not for the reason we're here today. We implore you to take positive action in advancing this bill in the name of humanity. Humanity that provides the necessary care and treatment to those with mental incapacities. The humanity to remove dangerous and unrepentant criminals from our streets. And the humanity that protects innocent, promising lives like Jillian's that are destined to make our world a better, more caring, and peaceful place. It's too late for our Jillian Ray, but we cannot allow her death to be in vain. We cannot allow others like her to be taken from us through horrific acts of preventable violence. Thank you.
Thank you very much.
I'm Jessica Ludwig. We didn't realize we could both speak today, so I have nothing prepared. But I just want to echo everything that my husband just said. And we are living every parent's worst nightmare. Our daughter had an amazing future ahead of her. We entrusted her to the care of Tennessee. She was only here for 3 months. And our lives will never be the same, and she was robbed of her future. And for us to learn that her life was taken by a man who should not have been on the streets given his long list of crimes. It's just inconceivable that somebody with that mental incapacity would just be placed back out in society to hurt people. So please take action. We don't want anyone to live this nightmare that we're living. Thank you.
Thank you. Members, do we have any comments or questions? You wish to speak as well? No?
Thank you, Chairman. As a matter of the House rules, Olivia did not know that she could testify today. So it's been willing to testify next week. So my office will get with your office about her testifying next week, as she is Jillian's roommate.
Yes. Okay. Very well. Thank you. Leader Lamberth.
I just want to thank y'all for being here today. I know that you don't want to be here. None of us would have ever wanted anyone to go through this. I appreciate your strength. I appreciate you sharing just a little slice of what your baby girl was and still is. I just thank you for being here today. It matters. It matters that she lived. It matters that you were here today. And it matters for us to be able to change the law. It is making a difference that you were here today, and your words in her life matter to us. And so I can't imagine the strength it takes for you to be here just a few months after this. But I thank you.
Representative Hardaway.
Thank you, Chairman. Thank you all for being here. I'm a girl dad, my baby girl, Allison. I just don't know if I could do what you're doing. But the fact that you are able to establish this legacy, in spite of the way that she was snatched out of your lives, it means something. I thank the chairman for the work he's done, but I really thank y'all for having the strength to be here today. The way that you've articulated the life of your daughter and why we need this legislation. It's extraordinary, an effort on your part, and I promise you we'll do our part. So once again, my condolences, deepest sympathies, and we pray God's grace upon you, your family, and all of her friends.
Thank you. Anyone else? All right. Thank you both. Thank you all for being here with us today and your words. Members, we'll go back into session. Leader Lambert, you're recognized.
Thank you, Mr. Chairman. And members, this creates a rebuttable presumption that when someone has been, again, diagnosed, have medical professionals, have attorneys been, that represent them, they've gone before a judge, and a judge has made a finding that that person is not competent to assist in their defense, then they would be committed. And again, that can be inpatient, it can be outpatient, it can be a continuation of care. The goal is to make sure these folks are not just out without the services they need. So that is what the bill does. I do want to thank publicly General Funk for being a strong part of this process. His office has previously prosecuted the person that committed this crime and is currently prosecuting that person. And I have reached out to that office, spoken to both he and his assistant district attorneys to try to understand. I've also reached out to our departments, our Department of Mental Health and others, and I appreciate their input into this as both mental health and Department of Development and Disabilities. The goal was to get this right so that we have a response for someone who is charged with a crime in the criminal justice system that is not just let them go so they can commit these type of horrors, so that that person gets the help they need and everybody else is kept safe. I stand ready for questions, Mr. Chairman.
Thank you, members. We have any questions for the sponsor, Representative Johnson?
Yes, thank you, Mr. Chair. So I guess my question is, in talking to attorneys, facilities are very difficult to come by already. They're looking for facilities for these type of folks. What do we have in way of facilities for these people? Because right now, they don't seem to be available.
So two answers to that. One, when a judge orders someone to go to a facility, that's where they're going. I mean, that takes precedent. I mean, that's a judicial order. It has to happen. And there's not a lot of judges that are going to suffer much patience when they have someone that they have ordered into a facility. So the departments are prepared for that. The different private facilities are prepared for that. They understand that. The second aspect of this, we are, as best we can tell, only talking about a couple hundred people statewide. I think the fiscal note on this, it goes into that in great detail, but this is not a flood of individuals that fit into this category. It's a very, I won't say it's a rare thing, but it is not a regular occurrence in court. Again, in 20 years, I mean, I've seen it over and over again, but in the counties that I practice in, it's a couple here and there a year, because these folks are not only not competent, but they're never going to be competent. Because when someone is evaluated for competency, the first thing they're looking at is, well, look, is this a temporary incapacitation? Is this someone that has a mental health issue that can be addressed through treatment? Is it a developmental disability that can be addressed through rehabilitated services? And if the answer is yes, then those cases are resolved, because that person eventually is able to discuss their case with their attorney. What we're talking about here are those few individuals that come through that really will never regain competency, because they are so far devolved in both their developmental disability and many times dual diagnosis with mental health. So we're not talking about a large strain on the system. There is a $1.1 million fiscal note. We have a $56.2 billion budget. We fund a lot of things through your tax dollars as Tennesseans. This is worth it. And so we are prepared for that. I've had those conversations with the department, and beyond the $1.1 million fiscal note, they have been very clear that they feel like that they definitely can handle what additional cases that this would generate.
Okay, and I guess you mentioned the dual diagnosis. That's a large part of my concern is those with intellectual disabilities. What sort of services does this bill provide for those with intellectual disabilities?
Thank you, Mr. Chairman. So the same services that we would provide through mental health, but obviously through very different providers. And so if someone has developmental disabilities, there are services that they need that can help them navigate society better and in a lawful way, that they would not be a harm to themselves or others, and very similar to what we do with mental health issues now. So they get them with mental health providers, they get them with the assistance they need. And with those that have developmental disabilities, again, it is different departments, it is different providers, but it is still the court saying, look, these people are not competent to assist in their defense. They have need of services. And then there would be a continuation of review from the court to ensure that those services are being provided. So whether it's developmental disability or mental health or a combination thereof, it's really about matching them up with the commitment and then really a follow through for the rest of time for whatever outpatient services and services that they need in the community. And I want to be crystal clear, and I've discussed this with the family. We're not talking about a commitment where somebody is inpatient committed forever. I mean, that is not both not reasonable and will not solve these problems. We are talking about identifying individuals that are not competent to assist in defense. Yes, committing them, but that starts a process where the entire system then is monitoring that individual who's been charged with a crime to make sure that they're not a danger to themselves or others anymore. So it is about getting that person services, quite frankly, because that's the right thing to do. And it also improves the safety of our communities.
Okay, and I guess that's also part of the concern. I know that there's a time limit because I have talked to attorneys across the state who are waiting placement, which usually means they'll wait in jail until that placement. So will those with intellectual disabilities get the services they need while they're awaiting in a jail?
To the best of our ability, absolutely. But again, and you've just heard from the Ludwig family, until it is safe for them to be released into society, they should not be released. And so I want them to get the services they need rapidly. I want that to happen very quickly. But the answer now is just release these individuals. And you just heard from a family that has unfortunately suffered the worst that you can imagine based on what the system does now. We can, shall, and should do better. My hope and what I think we should all work towards is that the window of when those services are provided is shrunk to almost immediate. But in the meantime, if there is a lag, it should be a lag that is in the benefit of public safety.
Yeah, I'm not disputing that. I just want to make sure that those services are in place, especially for intellectual disabilities, because they can become targets in a jail situation and that sort of thing. And we're not, this is, this situation is horrible. And yes, it definitely needs to happen. But there are some low level situations and crimes that would cause the same commitment as well. And so I just want to make sure that in those situations, and I want everybody to get the services that they need.
Thank you, Representative Howell.
Thank you, Mr. Chairman. First, I want to say to the family, I am deeply sorry for what you're going through. No one can understand what you're going through unless you yourself have lost a child. And my deepest sympathy to you. I also want to commend the sponsor for what I believe is a very well-crafted bill. One of the chief responsibilities of a government is to protect its citizens. And I believe this committee takes it very seriously. But this bill preserves the rights of the accused with legal representation. They have the care of a medical professional while being adjudicated in a court of law, and it addresses a serious issue with regard to public safety. To me, that's a well-crafted bill, and I appreciate the sponsor bringing it, and I'm glad to sign on as a co-sponsor. Thank you.
Thank you for that, Representative Towns. All right, Representative Hardaway.
Thank you, Chairman. To the sponsor, and once again, I appreciate your insight that you provided on this so far. And can you go a little further on how those individuals will have a pathway back before the court for periodic review?
Yes, sir, and thank you for that question. So this envisions very similar to what we do with not guilty by reason of insanity. So when someone is found not guilty by reason of insanity, they go under a judicial review with the court, where the court is getting regular updates. It's been several years it's been more than 12 years since I left the district attorney's office and came in to serve with all of you. But when I was an assistant district attorney, there was a young lady that fell in this category that was committed, that had a not guilty reason of insanity finding. I literally just heard the other day, and this has been 15 years ago, that she recently passed. For that entire time that I've been gone from the DA's office, she was under a review from the court, and the court got kind of, every 6 months got an update on her status. And so that is what we've envisioned here. And if at any point that person again is regains competence, there are some procedures they can go through to try to get from under that review. And as they're going through that, those services fluctuate depending upon their needs. Because as you can imagine, these folks are in pretty bad shape, sometimes both mentally or through developmental disabilities. And so that treatment plan can fluctuate. But the big win for both the Ludwig family and anyone else is that these folks will not be out there on the streets just unsupervised. Some of them may remain in inpatient treatment if that's what they need and if that's what society needs to remain safe. But it is a continuation of a plan of treatment that focuses on that individual's needs and the safety of the community.
Thank you, Chairman. And I just want to reiterate to the family, we're going to fight for that budget to make all of this a reality.
Thank you. Any other members? Questions of the sponsor, Representative Williams, you have anything? Okay. Without objection, we're now voting to send House Bill 1640 as amended on the full criminal. All those in favor say aye.
Aye.
Those opposed, the ayes prevail. You move forward. Thank you.
Thank you, Mr. Chairman, and to the Ludwig family, thank you very much for being here today.
Members, we're on item number 2, House Bill 994 by Representative Kiesling. You are recognized, sir.
Thank you, Mr. Chairman. I appreciate it. I do want to extend my thanks to you, Mr. Chairman, as well as the members of the committee for your indulgence last year in listening and considering House Bill 994. But at this time, Mr. Chairman, I would like to ask to take this off notice at this time, please.
Well, all right. Without objection, we'll take House Bill 994 off notice.
Thank you, Mr. Chairman.
Yes, sir. Thank you. Item number 3, House Bill 1384 by Representative Reagan. You are recognized on the bill. There is an amendment code 11929. Do you wish to proceed with that amendment?
Yes, sir. I'd like to put that amendment on the bill. It rewrites the bill.
Okay. All right. You're recognized on the amendment.
Thank you, Mr. Chair and committee. I stand before you today presenting a bill that rights some of the wrongs with modern day slavery, which is euphemistically called human trafficking. This bill is brought to me at the request of Thistle Farms. They are here to testify if the committee so desires. It's a Tennessee-based nonprofit serving survivors of human trafficking and prostitution, statewide and nationwide. Tennessee is the only state in the nation currently requiring people living with HIV who have been convicted of aggravated prostitution to register as a violent sex offender for their entire lives with no recourse. Input for this was received on this bill and is included in this amendment from law enforcement officers and all interested parties. This amendment does not remove the crime of aggravated prostitution, which was in the original language. The amended language basically does 3 things. It provides an avenue for trafficked persons to have their aggravated prostitution offense expunged and removes the requirement for anyone convicted of a new aggravated prostitution offense to register as a sex offender, and allows a person with an old aggravated prostitution charge to request removal from the sex offender registry as long as they have no other violations that would require them to remain listed. I cannot state strongly enough that our nation went through the throes of a civil war back in the 1860s to eliminate slavery. And yet today, we are countenancing it by not taking action such as this. I ask for a positive vote from you and stand ready to answer questions. I would also request the committee entertain witness testimony.
Thank you for that explanation on the amendment. Members, do we have any questions for the sponsor on the amendment? Representative Johnson?
Thank you, Mr. Chairman. I don't have questions. Actually, I just want to say thank you for bringing this bill.
Any other questions on the amendment? If not, we're now voting to attach Amendment Code 11929 on the House Bill 1384. Those in favor say aye. Aye. Those opposed? The ayes prevail. You adopt. We're on the bill as amended. Any questions for the sponsor? Seeing none, we do have Chairman Halsey.
Thank you, Mr. Chairman, and thanks for the bill. With an unsecure border, a lot of intel that I get from people in that arena say there's a big population of human trafficking from folks come across the border that are operated or owned by the cartels. Do you have any statistics or any idea out of 10 folks that you retrieve out of that, how many out of those 10 are border crossers?
Not at this time, sir. I will say this, though. It's public domain knowledge that a huge number, especially of the younger people coming across the border, and especially of young women that are pressed into prostitution to pay for their passage, and in some cases, for their own safety. They're threatened with life or other dire consequences if they don't. Our current law, unfortunately, if they have HIV and are convicted of this, they have it for life. They must sometimes return to prostitution just to be able to earn enough money to eat on. So this bill gives them an alternative path, and Thistle Farms can give you the details on that. They may have some other statistics. I'm sorry, sir, I can't help them.
Representative Towns?
Thank you, Mr. Chairman. Well, obviously, thank you for the bill. From your perspective, in the event that we pass this bill, what kind of impact can we truly expect that it will have on human trafficking in terms of decreasing it?
Sir, I can't give you a definitive answer on that. What this will do is more for the survivors,
right,
the victims, than it is to prevent the crime itself. I think the possibility for preventing that crime lies more in the hands of the federal authorities than it does us. But at this level, we at the state level have the power to ameliorate bad consequences for those who've been victims.
Yes, sir.
Mr. Chairman, thank you for that. I'd love to see in the future, even though the Fed has obviously some input and control, I'd love to see us at the state level begin to figure out how we can track and prosecute people that are doing this, because it's absolutely just been beyond the pale. It just hadn't been on top of the totem pole to get attention, but something needs to be done. And we know it's happening across the country, and we need to do something a lot more fierce about prosecuting, apprehending, and putting the people away that are forcing these women, and probably in many cases today, young boys, into this kind of diabolical conduct and behavior because of fear, of their lives. So I'd love to see us tag team and do something on that as well.
Thank you for that comment. I have 4 other bills that I think you're going to like coming up later.
Okay. Thank you, sir. Thank you, Mr. Chairman.
Thank you. Representative Fritz?
Thank you, Mr. Chairman, and to the sponsor, thank you for carrying this bill. Some of us who have traveled to our southern border to see with our own eyes what is taking place there validates the need for what I would recall in your measure here, a redemptive process. And redemption is always a beautiful thing, to be able to restore to these young people that have been victimized over time, the ability to stand on their own 2 feet. So I applaud you for the consciousness to send that, and that we are going to indeed need to, as my colleague just mentioned, be able to address this on a much larger scale, because our friends in Texas made it clear to us one thing, that human trafficking had exceeded the drug trade in their area of Texas. And they cautioned us that it's coming our way. So thank you.
Thank you.
Representative Moody.
Thank you, Mr. Chairman, and thank you, Chairman, for this bill. Just another way to look at this bill of the benefit of it. Way back in the day, I was involved with getting this. It was up to the discretion of the judge when these women who were charged with aggravated prostitution, and hearing the facts, he had the ability to not put them on that registry. But this fixes it, so there's no leeway. So thank you. And I'll just say, so you know, we are blessed in Tennessee to have these nonprofits that are in each division of our state that work with these women. And I'll never forget meeting Sheila, and what a story. She was charged with this. She had AIDS, and a friend of mine wanted to come and meet her. And she said, so you knew you had AIDS, but you did it? And she was very gracious. And she said, I did, because my pimp killed one of the girls in front of us for not going on and doing it, even though we knew. So when you hear those kind of stories, but that charge keeps these women from being able to go to our nonprofits that have residential, because there are other women there with children. And so this is huge for us, helping to keep these women out of that vicious cycle. And so I thank you, and just let you know that this is another benefit of what this bill is doing for our women. Thank you for being here at Thistle Farms.
Thank you for that. Any other questions on the bill? If not, we're going to go out of session. We're going to hear from Ms. Tasha Kennard. Did I say that correctly? All right. You'll have 3 minutes for comments. If you would, state your name for the record, then you can begin.
Good afternoon. I'm Tasha Kennard. I'm the CEO of Thistle Farms, and I'm honored to be here and speak with you today on behalf of the remarkable women survivors that we serve, and on behalf of the hundreds of women across the state of Tennessee that are served by other nonprofits doing the same work who are facing the same struggles. I'd like to extend my sincerest gratitude to the members of this committee for the opportunity to speak in support of this important legislative action. And thank you to our sponsor, Representative Reagan, and all of those who have signed on to support this bill. Today, you do have an opportunity to create and clear a pathway for individuals that have been trafficked in our state that will give them better access to meaningful employment and access to services and opportunity to create a thriving life. Recently, a graduate of Thistle Farms residential program who is currently on the sex offender registry shared her story with us. She's on the registry because of a 2009 aggravated prostitution charge. And I want to tell her story on her behalf. And out of respect, I'm not going to share her name, but I want to honor her today. My friend is from East Tennessee, and when she was 20 years old, she lost her mother, which was a devastating event for her. And that pain, that loss, and that grief was so great that she found herself turning to the streets and drugs to cope. While it isn't the choice that she would likely make today, she was young and in pain, and it's the path that her life led. Deep in addiction, she began dating a man who began to abuse her and rape her. And as a result, she contracted HIV. He then put her in a situation where she had no other choice but to prostitute herself in order to sustain their addictions and their housing. In 2009, she was arrested after getting into a car with an undercover cop. And when she was tested, it was discovered that she had HIV, and she went to prison. Upon release, she was informed that she would be on the sex offender registry for the rest of her life. Every time she applies for a job or tries to find a place to live or access recovery services or just simply try to exist in this complicated world, her name is found on the sex offender registry, and many programs will not support her because of that. This list identifies her as a violent sex offender, often regarded as a pedophile just for being on the list, which is not the case. 2 years after she was released from prison, she had the opportunity to join the Thistle Farms residential program. And she shared with us, Thistle Farms didn't care about my status because they looked beyond the list and tried to understand what happened to me and saw that I would never be able to break this cycle of homelessness, of addiction, and incarceration without grace and understanding, without opportunity to start anew. Once she graduated from the program, she ran into obstacle after obstacle after obstacle. She couldn't find a place to live. She couldn't find the care that she needed to take care of herself. She couldn't maintain a job. Because of this law and the abusive relationship where a man raped her and forced her into a life of prostitution and gave her HIV, she has been denied from recovery programs, jobs, and homes.
Ms. Kennard, our 3 minutes are up.
I apologize.
No worries. Members, do we have any questions for our guest, Representative Johnson?
Thank you, Mr. Chair. So is there a happy ending to this story? Is she doing well now? I'd like to know those things.
She is about to celebrate 6 months sober, and she is employed at Thistle Farms.
That's great. Any other questions, Representative Towns?
Thank you for that really melancholy story there of somebody's life. Thistle Farms, they're located where? Are they throughout the state or where are they specifically located?
We're located here in Middle Tennessee, right off Charlotte Avenue, and we serve the entire state of Tennessee and have a sister network throughout the entire United States, offering over 600 residential beds for women who are victims of human trafficking.
So who is your sister group that's affiliated with you in Memphis, Jackson, Tennessee as well?
Restore.
Restore?
Mhm.
Okay, but are you all in Memphis as well? Thistle?
We affiliate with them
Okay.
and take referrals from one another. And there's
Okay.
also an organization called Thistle and Bee there in
Okay.
Memphis.
All right. Thank you for the work you do.
Thank you.
Representative Hardaway.
Thank you, Chairman. And this might be a question for legal, but I'm going to throw it at you. What's the process by which these individuals are tested in the first place? Is it because they're arrested for a certain crime that that's the probable cause, so they're tested? Or, and if you don't know, that's fine. We'll go to legal.
I would defer the legal answer to your legal advisors, but I do believe because they are arrested for aggravated prostitution, the way the law works is they're automatically tested for HIV. And if that test is found to be a positive result, they are then added to the sex offender registry for life.
And would this test be primarily for HIV or only for testing only for HIV? Would it include other infectious diseases?
I don't have the answer to that question today.
Okay, at some point, Mr. Chairman, I'd like to get that to legal.
Yes, sir,
Thank you,
Representative. And if it's okay with you, we're having some doing some research up here. We'll get that information to you between now and full committee or in full committee as well, if that's okay.
That'll be fine, sir.
Okay, thank you. Any other questions for our guests while we're out of session? If not, we're going to go back into session. Thank you for being with us today for your
Thank you.
testimony. All right, we're back on House Bill 1384 as amended by Representative Reagan. Any questions for the sponsor on the bill? Question's been called. Any objections? Seeing none, we're now voting to send House Bill 1384 as amended on the full criminal. All those in favor say aye. Those opposed? The ayes prevail. You move forward.
Thank you, Mr. Chair and committee.
Thank you.
Best lunch you'll ever have.
Members, let's skip to item number 5. Item number 5, House Bill 1727 by Representative Gant. You are recognized. No amendments with this bill, so
Piece of legislation is brought by our DAs here at the DA conference here in our state. And just to summarize, this permits the prosecution of a parent or guardian who allows their minor child under the age of 18 to be cared for by a registered sex offender or to be an accompanied minor in the home of a sex offender. The offense will be a Class A misdemeanor and requires the parent or legal guardian to act knowingly. And this is, and I stress that, knowingly. If they are not knowingly aware that the person is a sex offender, then this would not apply to them. And that section is carved out in this legislation. This addresses a problem that is recurring here in the state of Tennessee, and I'll drill down into an example. In the 8th Judicial District alone, there have been 3 recent cases where a mother allowed her minor child to be cared for by a known sex offender. They prosecuted the sex offender each time, but could not prosecute the mother. After an unsuccessful attempt to prosecute under the aiding and abetting statute, the need for this legislation became apparent. So that's why I am standing before you on behalf of our DA's conference to present this legislation. Mr. Chairman, I'll try and answer any questions that members have. Our DAs are not here today. They're at a off-site function. And if there's some questions I don't understand, we can possibly get those answers in full committee, but I'll try to do my best to answer today.
thank you for that explanation. Representative Towns.
Thank you, Mr. Chairman. This is your lucky day. I'm promoting you to the status of DA, so you'll be able to handle any and every question that is thrown at you today, and you look better than the last DA I saw as well. Now, this is a good bill, I believe, but I have a question that I ponder as we speak. What if that's a person that's babysitting, so to speak, or caring for? What if it's a relative? Unfortunately, that happens in this world. How do we address that?
Mr. Chairman, I do not know the answer to that. I'm not an attorney, obviously. I don't know if Leader Lamberth is familiar with this statute and would want to expand on this or not. He might be willing to provide some knowledge of that. Otherwise, I can get the answer for you.
Question is, if it's a family member that's caring for this child, the family member is a registered sex offender.
Yeah, parent or guardian.
Would you like to talk to legal services about this?
Well, if legal can answer it, fine. If not, we can defer. I don't mind giving the gentleman a chance to get it from the DA. So I want it accurate on the record.
Mr. Chairman, I think we do have somebody here. I think Miss Katie Coates might be willing to testify if you want to go out of session.
If you don't mind,
that
sir.
answer.
All right, we'll go out of session.
Thank you, Mr. Chairman.
Ms. Katie Coates from District Attorney's Conference, if you will, introduce yourself. For the record, you'll have 3 minutes.
That's not the red button. There you go. You got it?
Okay, yes. Katie Coates with the District Attorney General's Conference, and I will do my best. I think there is a carved out exception if it's the parent that is the registered sex offender that we have addressed in the legislation.
Okay.
So that's still in place.
So that would not extend, just asking, to the uncle or grandfather or the guardian?
No, sir.
Okay. So, and that at 17 years old, which is under 18, or 17 years old, I wouldn't think they would need anyone to guard unless they mentally, challenged or something of that nature. But at 17 or 16 years old, I would think you could kind of defend for yourself as well too. But so that would be a misdemeanor for the parent that allowed that to occur.
That is correct.
Granddad or uncle or something of that nature. Okay. All right. Thank you.
While we're out of session, you have a question for our Representative Hardaway?
Yes, I'll yield to Rep. Johnson.
Okay. Representative Johnson.
Thank you, Mr. Chairman. I like the bill. I'm just curious, want to clarify something because knowingly, does that mean like I heard a rumor that maybe, or does it mean that you absolutely have knowledge that this person is on the list? Or
You would have to actually have knowledge.
okay, thank you. Appreciate that.
Any other questions for our guest while we're out of session? Yes, sir, Representative Hardaway.
Thank you, sir. I want to make sure I understood the Q&A with you and Rep. Towns. Is there a different charge for for relatives? Same charges as if it was a stranger that had access?
No, sir, it wouldn't be a different charge. There's a specific carved out exception where if it's a parent or guardian, there's a different statute that deals with that. This bill does not address that nor touch that.
Okay, I'm clear. Just one more question. What's your role with the conference?
I am the legislative coordinator.
All right, where is that executive director? Where's that guy?
They are in DC. They left me here and
Well, you're doing a fine job. You need a raise. Thank you, Mr. Chairman.
Thank you. Any other questions while we're out of session? Seeing none, we'll go back into session. Thank you. All right, we're back on the bill. Any questions for the sponsor? Questions called? Any objections? Seeing none, we're voting to send House Bill 1727 on the full criminal. All those in favor say aye. Those opposed? Ayes prevail. You move forward. Thank you.
Thank you, committee.
Members, we will continue down the calendar to item number 6, House Bill 1658 by Leader Lambert.
Thank you, Mr. Chairman, members of the committee. Very straightforward bill. It just, instead of an A misdemeanor, it would be an E felony for someone during an active court proceeding to attack the judge, a litigant, a witness, a bailiff, a juror, the lawyer. This actually happened to a friend of mine. He was appointed to a case to represent a gentleman who was facing a pretty significant prison sentence if convicted. They had a falling out amongst attorney and client, but my friend as an attorney was appointed to the case and was doing the best job he possibly could, but the defendant just was very upset with him. And so he kept telling the judge, the defendant did, that he wanted another attorney. The judge kept telling him, that's your attorney. He's competent. He's been doing this for decades. So after the jury was in the box, in the middle of this trial, just as they were just getting started, this defendant stood up, who was unshackled because it was a trial, and just decked my friend. He reached over and just punched him right in the face. And so immediately pandemonium reigns in the courtroom. They, arrest the defendant, and he's smiling as he head out of the courtroom. One of the guys asked him, man, were you so happy before you just got arrested for assault? He said, yeah, but I get a new lawyer. So a felony would at least hopefully dissuade someone who is facing a serious charge from attacking their own lawyer or a judge or a witness or a bailiff during a court proceeding. We're not creating special classes here, but in that circumstance where you're in a court proceeding, every person in that courtroom should be safe from other individuals in that courtroom. That's what the bill does. It creates an E felony instead of an A misdemeanor in that circumstance. And misdemeanor.
All right, members, any questions for the sponsor, Chairman Halsey?
Thank you. And you said that it doesn't create a special class, but if a person was sitting in the audience and they got punched by this guy, are they protected with the same enhancement?
So you would have to articulate that it's the victim's participation in the judicial proceedings, and a reasonable person would regard the context of provocative. I mean, it is the victim's participation. So you would have to prove in front of a jury in that circumstance that that person, by viewing the proceedings, is participating. It's more for the lawyers, the bailiff, the judge, the witnesses, the jurors. But it would be a bit of a stretch for that kind of circumstance for someone who's just visiting a courtroom. But I think it would be a stretch, but maybe somebody could make that case.
All right, members, we do have someone here to testify on this bill, so we are going to go out of session. Hear from John Gentry. You would, sir, find you a seat there. You can turn on that microphone, introduce yourself for the record, and you'll have 3 minutes for
My name's
comments.
John Gentry. I'm a candidate for state senate, practiced 20 years.
Objection?
Am I on?
This isn't a speech for political office, Chairman. If he wants to testify against the bill, that's fine, but he's not here to make a campaign speech.
I'm directly on the bill, Chairman.
Okay. All right, let's start the introduction over again. State your name, please.
Yeah. My name's John Gentry. I practiced more than 20 years as a certified public accountant. I'm a former Force Recon Marine, and I'm a concerned citizen.
Thank you.
Our Tennessee Constitution, in Article 11, Section 8, it says the legislature shall have no power to pass any law granting any individual or individuals rights, privileges, immunity, exemptions, than such as may be by the same law extended to any member of the community. We just heard Representative Lambert say that this particularly pertains to judges and lawyers. Article 11, Section 8 was written because the Tennessee pioneers that came to Tennessee, part of the reason that they left was due to social class distinctions, which they despised. They believed that a man ought to be judged and his character is reflected on the work that he does and on his deeds, not by social distinctions. So there's a good reason why the founders put this language into our state constitution. When we look at the bill itself in here, sorry. When we look at the bill itself, it says knowingly causes physical contact that is extremely offensive or provocative, but not limited to. So it's void for vagueness. What's extremely offensive or what's provocative? And what if the person is provoked? And we have corrupt court proceedings that happen on a routine basis in this state. And I would be provoked if I were subjected to corrupt court proceedings and maliciously prosecuted. And we see it happening today with President Trump. I think he's being very maliciously prosecuted. But we see that happening in our courts all the time. Now, if I'm not a party to the proceeding, and Representative Lambert just said this, if they're not specifically a part of the proceeding or they're not a court worker, they're not covered under this law. So very, very specifically, it's repugnant to Article 11, Section 8. And what about the people in legislative proceedings? Why aren't they protected? So I think, first of all, the committee has to stand by their oath to support the Constitution of this state. I think this language, extremely offensive, provocative, if you're getting in there and you say, you're a liar, this is wrong, and you accidentally punctuate it a little bit too much and make contact, now you've committed a crime according to this statute for socially distinct persons for which legislation is prohibited in our state constitution. So I would encourage the committee to follow our Constitution. There was a reason that the framers put Article 11, Section 8 into our state Constitution. If anybody has any questions about why I think that this is entrapment in corrupt court proceedings, if somebody is provoked, I think that's entrapment.
Ms. Gentry, your 3 minutes have passed.
Say again?
Your 3 minutes are over for your
done.
testimony. So any questions for our guests, Representative Towns?
Thank you. I got a question for you. As it relates to proceedings in court where cases are adjudicated and you got to get through that process, what do you think should be done when you have a situation where you have a person that's unruly and assaulting others? What should be the order to keep that under control?
Thank you, Representative Town. We already have assault statutes on the books. There's chapter after chapter under Title 39 that has assault under there. It's already under there. What this legislation puts in is extremely or offensive contact, not limited to spitting, throwing, offensively transferring bodily fluids. What if you shoulder a guy? Now you committed a crime, and like I said, you're pointing, that's a crime. But we already have assault in our criminal code, and people in that courtroom are already protected. But what this adds is contact. It just says physical contact. So if you touch them and it's provocative or extremely offensive, you're now subject to malicious prosecution. And I think that is in gross violation of Article 11, Section 8 of the Tennessee Constitution. You cannot pass special interest legislation to benefit an individual or individuals, and that's exactly what this law does.
Thank you, sir.
Yes, sir.
Thank you, Mr. Chairman.
Any other questions for our guest? Seeing none, we're going to go back into session. Thank you for being with us today. We're back on House Bill 1658. Any questions for the sponsor, Leader Lambert?
Thank you, Mr. Chairman, and I appreciate whatever exactly that was, but the assault statute is already on the books, and what the gentleman just quoted from is the current assault statute. This makes it an E felony. I personally don't think folks should be attacked in a courtroom. There may be others that are perfectly fine with that, but I am not. So I would ask members to please vote in favor of the legislation.
Any other questions? Seeing none, we're voting now to send House Bill 1658 on the full criminal. Those in favor say aye.
Aye.
Those opposed? The ayes prevail. If you wish to be recorded as a no, please see the clerk. You move on to full criminal. Item number 7, House Bill 1680 by Representative Alexander. All right, you are recognized on the bill.
Thank you, Chairman, and thank you, committee. Sometimes we do bills and they have a domino effect to them, and that's what happened to me last year. You probably remember that I came to you with a bill concerning applying financial abuse to the domestic violence code. And we did that. And in the process of doing that, it opened up senior citizens and possibly self-neglect. And what happened was it took APS, Adult Protective Services, out of the loop. We need them back into the loop. What I'm bringing you today is legislation to start back the APS process. I'll give you an example of what happened in my community. We have what's called First Tennessee Development District. We all have those districts. They take care of a lot of things for the good of the people in our community. And one such thing is coordinate our senior care. They got a call that they felt like a senior was in possibly self-neglecting or something was wrong. They couldn't have police go with them because APS is not involved. They go into this house, this woman does, and in the room that the patient was in, her bed, she was a large woman, her bed had fallen through the floor of the house. She opens the refrigerator, there is mold, bread, there is soured milk, and that is all that's in there. She opens up the cabinets and there's rats running everywhere. She quickly calls, she knows she can't lift this patient. She calls EMS, they come, they take this woman to the hospital. The ER doctor calls her within 10 minutes of being back into her car, and he says to her, "We have to take this woman to surgery immediately because we've got to remove all the cockroaches that are embedded in her back." We are sending our workers into the field with no protection. They need the police there. They need adult protective services there because they don't know what they're walking into. So I ask that you really consider this bill to amend the good bill that we had last year for financial abuse, but sometimes we just don't know what the effects are. That's the meat of my bill.
Well, thank you for that, Chairman Halsey.
Thank you. In essence, we always had this classification before.
That is correct.
It got screwed up last year somehow and dropped out. You're just putting it back in.
That is
It's
correct.
not a new thing.
That's correct.
Okay.
Any other questions for the sponsor? We do have testimony here today. All right, we are going to go out of session to hear from John Gentry. You'll have 3 minutes for your comments after you introduce yourself for the record.
Thank you, Chairman. My name is John Gentry. Taking a look at this legislation, what it's doing is it's taking out the phrase on the definition of abuse and neglect, and it says what they're taking out is the caretaker, so that now self-neglect is self-abuse. And I wrote about this on my social media page, and I want to read to you some of the comments that I got. This law will cause many elderly to stop going to the doctor and be fearful to tell the doctor about their mobility or memory problems. Another gentleman commented, he said, "This is messed up. When you've posted, 'Has my wife concerned?' they could twist things to make her seem like she's neglecting me, even though she's not. I was bitten by a spider, had to go to the hospital. They thought I had a bed sore. So I can see how quick this will get out of hand. There are meds they demanding I take, but those meds are bad for me. I have reactions. They could try to force that in me. I'm supposed to take Synthroid. It causes heart issues. They won't care." And here's the important part of this. This person commented and she said, this is very similar to what happened in this movie called I Care a Lot. We watched it in nursing school for us to see the power other people held over the elderly. I want to read you the plot, and this is what I'm afraid of. And they're teaching this in nursing school as an example. Here's the plot. Maria Crayson is a con artist who makes a living by convincing the justice system to grant her guardianship over elders who she pretends cannot take care of themselves. She places them in an assisted living facility where they're sedated and lose contact with the outside world. She then sells off their homes and assets, pocketing the proceeds. And that's what I'm afraid of. So you go to the doctor, you have cataracts, you got a bed sore. The doctor is required to report that to social services. So social services comes over and they do an investigation. And I agree from the testimony, if we've got something like that, they need to be taken into state care. But what we may see is people that are okay taking care of themselves forced into state custody. To get custody of them, they're going to have to petition a court. So the court is likely going to appoint a guardian ad litem. The guardian ad litem is likely going to start liquidating assets to pay for his attorney fees, to pay for assisted living care, and they're going to deplete that person's life savings under color of law. Now, for myself, if I am so bad off that I need to go into assisted living care, please let me die alone in my home. I would rather pass away in my home amongst my own memories and memorabilia in my home. I don't want to spend my last days in assisted living getting my diaper changed and spoon fed. I really don't.
Ms. Gentry, your 3 minutes are up.
So I encourage the committee to carefully consider your enabling confidence men. to
Any
take advantage
questions
of the
for our
elderly.
guest, Chairman Halsey?
John, just a second. Come back. John, this was on the books before as a category that Human Services investigates. And the reason I say that is because I was reading last year's manual, and this is one of the categories that they investigated, like I don't know, 1,200 complaints or so, and found that like 110 of them were justified. So it's not a new category that they're adding. I mean, I understand you're concerned about it. I just want you to understand this is not anything new. It has been the protocol for quite some time. It's just last year with this bill, somehow the wording, it got dropped off of there, and this is putting it back in. It also shields law enforcement when they go on a call like this and have no idea what to do, and it's not in their bailiwick. They end up sometimes trying to solve the problem when it's not really their turf. But I just want you to know it's nothing new.
I went back and looked at the existing legislation that's on there now, and I was not aware that this had existed before. But these kind of laws scare me. They really do. That people that, not everyone. I mean, there's a lot of good social workers that are taking care of the elderly. I know that. But we need a mechanism where when the unscrupulous go in there and take advantage of them. And personally, I think, I don't know when that original legislation hit, but, since the beginning of time, we haven't needed to protect the elderly from abusing themselves or neglecting themselves. I mean, we really haven't. And I think this is something recent that we've had. And if it fell off the books, I don't know how that would happen, but let it stay off.
I will say this, I've received some phone calls from law enforcement, having served in law enforcement. When you walk into a situation where you're doing a welfare check on someone, a neighbor has not seen someone for several days, and so you go into the home and you find someone that's laying there in a situation as the sponsor of the bill has presented. That was a call that we would make to APS to help aid in that. Now law enforcement, that tool has been removed from them, and it was just some type of oversight or clerical error in a piece of legislation that occurred last year, from my understanding, that occurred, but it has removed that ability. And so now law enforcement agencies are calling APS, and they're telling them, we can't do anything for you. We're no longer statutorily allowed to do this because this definition was removed of self-neglect. And so we have someone here that is willing to testify from the department to help explain some things. If there are any other questions for our guest, Mr. Gentry, if not, we'll move on to the next person, Ms. Callan Schmid. Welcome to the Criminal Committee. If you will introduce yourself for the record, you'll have 3 minutes for your comments.
Good afternoon, Chairman and members. My name is Callan Schmid, and I'm the Assistant Commissioner for External Affairs for the Department of Human Services. Thank you for the opportunity to speak on HB 1680, and thank you to Representative Alexander for carrying the bill and being a passionate supporter of this topic. This would restore APS's ability to investigate self-neglect and take action if necessary. For the almost 50 years that APS has had this authority in law, and then it has been bolstered by case law. That authority was inadvertently removed last year, and APS is seeking to restore that authority. APS only has the authority to intervene granted to it by the TCA and by our rules and policies. APS does not intervene unless there is imminent risk of harm, the client lacks capacity, and there is no one else willing or able to help take care of that adult. In that case, APS will investigate and attempt to offer voluntary protective services. APS always attempts to take the least restrictive measures possible while still protecting the vulnerable adult. If none of those interventions work, APS has the authority to go to Chancery Court to pursue either custody or conservatorship to ensure that the individual gets the help that they need. Our APS workers are doing an incredible job in this work, and it is a challenge every day, and we need to make sure that they are able to help our most vulnerable citizens. And with that, I'll be happy to take any questions.
Thank you for that explanation. Any questions for our guests? Representative Hardaway.
Thank you, Chairman. I just don't want her to get away without a question here. But thank you for being here, ma'am. Thank you for the work that y'all do. There's a reference in my summary of including self or expanding on the definition of what constitutes abuse and neglect by including self-neglect. So is self-neglect being put back, or tell me what the relevance is?
Yes, sir. So last year, a change in the definitions was made where it added by a caretaker to every definition of abuse yes code. So by a caretaker, which removed self-neglect. So we're just sticking it back in there.
All right. So in essence, what the sponsor has done is secure a problem that we created. And I appreciate you working with her. We quite often have legislation that we pass with unintended consequences. And not often enough do we have legislators who have the courage to come back and say, this is how we make that bill, make that law at that point better. So thank you for working with the sponsor.
Any other questions for our guest? Seeing none? Oh, sorry, Representative Howe.
Thank you, Mr. Chairman. And just to be clear, sometimes I get a little fuzzy and I want to be clear. This law had been on the book for 5 decades.
Since 1974, the establishment of APS.
Was there, Mr. Chairman?
Yes, sir.
Has there been a history of abuse by authority figures?
Not to my knowledge.
Thank you very much.
All right. Any other questions? Seeing none, we're going to go back into session. We're back on House Bill 1680. Any questions for the sponsor? Seeing none, we're now voting to send House Bill 1680 on the full criminal. Those in favor say aye.
Aye.
Those opposed? Ayes prevail. You move forward. Thank you.
Thank you, Chairman. Thank you, Committee.
Item number 8, House Bill 1688 by Representative Bolso.
Motion.
You are recognized.
Thank you, Mr. Chairman and members of the committee. This is a bill that simply seeks to repeal part of our motor vehicle code that is no longer in use. Back in 1971, this statute was passed that authorized municipal governments, if they chose to adopt a resolution that would allow someone to post a driver's license as bail for a traffic-related offense. The statute is no longer in use. Municipalities no longer use this form of bail, and the administration has brought this bill effectively in order just to clean up the code, to remove this particular code section from the motor vehicle code because it is no longer in use, and driver's licenses are no longer used anywhere in Tennessee as bail for traffic-related offenses. And with that, Mr. Chairman, I stand ready for questions.
Thank you for that explanation. Is this your first opportunity to grace the Criminal Justice Subcommittee? Since
I
you've
believe
been
it
in
is,
the-
yes, Mr.
Welcome.
Chairman. Thank you.
Any questions for the sponsor, Leader Lambert?
Representative Bolso, thank you for carrying this bill. I always appreciate opportunities to shrink the size of government and reduce the size of the green books over there. So taking out antiquated laws is something that doesn't get a whole lot of attention, but it is good to clean up the code. And I know as an attorney, you appreciate that, but it's there's no sense having things in the code that are no longer utilized and no longer needed. So thank you for carrying the bill.
We do have some that are signed up for testimony on this bill. We're going to forego that and save that opportunity for the full criminal committee. I'm sure there'll be additional questions for that individual then. Any other questions for our sponsor? Seeing none, we're voting to send House Bill 1688 on the full criminal. Those in favor say aye.
Aye.
Those opposed, the ayes prevail. You move forward.
Thank you, Mr. Chairman. Thank you, committee.
Thank you. Item number 9, House Bill 1620 by Representative Gillespie. You're recognized.
Thank you so much, Mr. Chairman. This is more or less just a little bit of a cleanup bill. Right now, what we have is we allow law enforcement to, under a certain set of rules, to utilize drones for providing coverage, whether it be search and rescue or some sort of investigative things like that. And what this is doing is just expanding the sunset to make it permanently. I think we can all realize that drones are here to stay, and they're very useful and very helpful. And that's really what this is doing. With that, I welcome any questions.
Thank you. So you're removing the sunset.
Correct.
Okay. Any questions for the sponsor? Seeing none, we're voting to send House Bill 1620 on the full criminal. Those in favor say aye. Aye. Those opposed? Ayes prevail. You move forward. Item number 11, House Bill 1719 by Representative Gillespie. You're recognized.
Thank you, Mr. Chairman. So what this is doing, very simply, is it's when someone is arrested and they're in front of a judicial commissioner, the judicial commissioner will use a series of factors to determine what the bail amount should be set. And what this is doing is it is removing one's financial condition as a consideration for that topic. So right now, at least where I live, there is quite the revolving door of people going in and out of the criminal justice system. And this is just allowing one more tool for law enforcement and the DA's office and others to have to help fight this problem that we have going on in my community. With that, I welcome any question.
Thank you, Leader Lambert.
Thank you, Mr. Chairman, and Representative Gillespie, thank you for carrying this. I don't think any of us on this committee that can truly understand what your community is going through, besides potentially those that represent that area. And we have a couple of members here that do represent areas of Memphis, and you all are dealing with a violent crime issue that none of the rest of us have ever seen in our communities. Last year, there were 398 murders in Memphis. That's 398 families, 398 lives lost, 398 families that will suffer for generations. And I applaud your efforts to try to, in a small way here, just address some of the rampant violent crime that is in your community. I hope that others will join you in this, but it is a small thing to say, and we had a bill just last week that dealt with making safety of the community the first thing they're looking at. That really should be what they're focused on. I mean, it should, when setting bond, it's what's their criminal history, what's their length of time in the community, what is going to continue to make sure that they're safe, the community's safe, and to make sure that individual is going to show up to court. Based on a conversation you and I had several months ago, it seems like in your community, they've made this ability to pay the absolute number one and only thing they're going to look at in a lot of circumstances. I believe I remember reading a story where there is a young person who is charged with murder, first-degree murder, that received an ROR and was just let go to go right back out and commit the same kind of heinous crimes. So I appreciate you bringing the bill. I'll certainly be in support of it. There's a whole list of other things that they can look at when setting a bond, but to say that this is going to be the number one thing, which is what has happened in many of your courts, is pretty ridiculous. And so I appreciate you fighting for your community. We as Tennesseans should all be with Shelby County and specifically with Memphis, because every Memphian is a Tennessean. And they have an amazing city, and you have an amazing city. But we got to get a handle on this violent crime. So thank you, sir, for bringing the bill.
Thank you, Representative Johnson.
Thank you, Mr. Chairman. Yes, my concern is we did talk last week about the hierarchy, and I think Representative Lamberth's bill put community safety at the top of the hierarchy. My concern is if you remove it totally, is that not unconstitutional? Our Constitution is very clear about reasonable bail. And that is part of our Constitution. So that's my question. I've talked with attorneys. I've talked with folks who think that this might be unconstitutional.
Thank you, Representative. I would say that there are other factors that are still going to be determined. Your employment, for one, which, let's be honest, is an indication of something. The history of how long you've been in that community. So this is not a blank check by any means.
Yes, thank you. I understand that it's not a blank check, and all of those things are important, the entire hierarchy together. But to remove something that is clearly lined out in our Constitution seems like we're heading up a bad road.
Chairman Halsey.
Thank you. The test for reasonableness to me should be what's reasonable for this specific crime, not geared to the person that's the defendant. But that was going to be my follow-up question to that is in the case in Memphis, is this happening where the reasonable bond for this particular crime is $5,000, but the defendant is saying, well, you know, I don't have any money, and so the bond is reduced to $500. Is that what's happening?
Thank you, Mr. Chairman. And yes, Mr. Chairman, in cases that has happened. And that's what I'm trying to, you know, if it happens one time and someone is, you know, worst case scenario, someone's life is lost, then yes, that's what I'm trying to prevent right there.
Okay, thank you.
Members, I will say we're about to be out of time and we do have someone here to testify. So without objection, we'll go out of session to hear from Josh Spiker. I hope I said that correctly.
It's Spickler.
Spickler.
But close enough. I've been called worse. Thank you, Mr. Chairman.
They dropped the L out of there, so sorry about that.
My name is Josh Spickler. I'm the executive director of an organization called Just City. I moved from this area to Memphis more than 30 years ago, where I went to college, I met my wife, we have 2 kids. I live in Memphis, it's my home. And yes, we're having a tough time. We're not perfect, but we've made some changes recently that I've been directly involved with to this bail system, not changes to the law, but changes to how our community decides who stays in our jail and who gets out. I stand here representing dozens of people, really, members of Shelby County government, members of other organizations, community advocates, who over the last 3 years have taken a long, hard look at the section of the code that we're talking about changing right now. And what we did was we introduced individualized hearings to this decision process. We gave attorneys to the folks who are being accused of crime quickly, within 72 hours. We provided additional information via pretrial services to the magistrates who are making these decisions. And I'm here to tell you that in a little less than a year, when we ran the data yesterday, the bonds for violent crimes in Memphis have gone up by 18% since we started taking a closer look at these folks who are coming into our jail. Changes like the one that you're considering right now really do upend the bail statute as it exists in Tennessee. This is a statute that's never been held unconstitutional. It's a very good statute. As someone who's been working on this issue for a long time, I can tell you the pieces are in place if you do what we've done in Shelby, and that is make sure we follow the law, and the people who need to be in custody will be held in custody, and the many, many folks who don't will be released. And to Representative Johnson's query about financial ability, it's absolutely necessary to consider that, or else you're making detention orders that can't be defended constitutionally. So I'm here as a representative of Shelby County saying that we're on the right track with regard to pretrial detention. We're on the right track with the process that we're employing to do that. And we're asking you to not change really fundamental parts of what is a pretty good state law. And I'm happy to take questions if you need to.
Members, we've got about 45 seconds left in committee. So if you do have any questions that you think of for the guest, we can provide that email address to you or contact information later, and we'll get back. But thank you for being with us today. We're going to go back into session. Members, all bills, House Bill 1719 and all others on the calendar that were not disposed of today will be rolled to next week's calendar, and we are now adjourned.